Hi guys, welcome to this session of Legal GK. Today we're going to be discussing current affairs between 15th July to 30th July, so the second half of July. And the first one that we have today is that the Guwahati High Court has taken suo motu cognizance of the second wave in Nagaland, Mizoram, and Andhra Pradesh. So the reason that I have chosen this particular article, even though the facts of the case are not that important, is because हमने recently न्यूज़ में बहुत सारे ऐसे आर्टिकल्स देखे हैं जहाँ पे कोर्ट ने suo motu cognizance लिया है, especially कोविड के रिलेशन में. So, for instance, you have the Delhi High Court taking suo motu cognizance. Allahabad High Court has taken suo motu cognizance. जितने भी hospitals थे दिल्ली में which ran out of oxygen, उनमें भी दिल्ली suo motu cognizance लिया गया या PILs फाइल हुई हैं. सुप्रीम कोर्ट ने suo motu cognizance लिया था कावड़ यात्रा के रिगार्डिंग. तो ये suo motu cognizance वर्ड बहुत ज्यादा आ रहा है, and I think we should take every opportunity to study this concept, especially because it has been brought up so many times. So what is suo motu cognizance? Suo motu एक Latin word है. इसका मतलब होता है on its own motion. On its own motion मतलब the court can take action on its own. Normally क्या होता है, कोर्ट तभी एक्शन ले पाता है जब कोई कंप्लेंट या सूट फाइल जब कोई कोर्ट में कंप्लेन या सूट फाइल करता है. सो सुओ मोटो कॉग्निजेंस में ये चीजें नहीं होती, क्योंकि ऐसे कुछ इश्यूज होते हैं जहां कोर्ट को अपने आप ही एक्शन लेना पड़ता है. इट कांट वेट फॉर somebody to come to it to file a suit and then resolve the problem. So this is a concept under something called epistolary jurisdiction. ये 1970s में बहुत popular हुआ था, and it basically means judicial activism, that the court goes out and does something, takes action, solves a particular problem without somebody having to approach it first. So this is judicial activism. So basically, it's not going to wait for anyone to approach it. It is going to take suo motu or action on its own motion. But what happens is that sometimes this power is abused. So this is something that is a very controversial issue amongst a lot of social media debates and like debates between the executive and the judiciary. So this is a really important concept, and it will keep coming up in the news again and again. So the Supreme Court or the High Court has this power. ये power हर court exercise नहीं कर पाता. आपके district courts या junior division के courts ये power नहीं exercise कर पाते. ये सिर्फ Supreme Court और High Court पे limited है. And the Supreme Court takes this power under Article 32. The High Court exercises this power under 226, Article 226 of the Constitution. Okay. But how is this power exercised? Lots of times what happens is the court reads a news article or a headline somewhere, or it may even receive a letter. लेकिन basically कोर्ट को कुछ ऐसी इंफॉर्मेशन मिले जो कोर्ट को लगे कि हाँ ये रिलायबल है और इसके बेसिस पे हम एक्शन ले सकते हैं. दैट इज द एसेंस ऑफ सुओ मोटो कॉग्निजेंस. सो फॉर इंस्टेंस इन द केस ऑफ कावड़ यात्रा क्या हुआ था, सुप्रीम कोर्ट ने न्यू इंडियन एक्सप्रेस या इंडियन एक्सप्रेस की हेडलाइन पढ़ी थी और उसमें लिखा था कि द यूपी गवर्नमेंट इज होस्टिंग द कावड़ यात्रा. सो दैट इज एन इशू वेयर द सुप्रीम कोर्ट फेल्ट कि अगर हम वेट करेंगे और कावड़ यात्रा होने देंगे या फिर एक्शन बहुत लेट लेंगे तो शायद कोविड केसेस बढ़ते जाएं और शायद सेकेंड वेव के बाद थर्ड वेव और जल्दी ही आ जाए या फिर देयर माइट बी मोर डेथ्स. सो द सुप्रीम कोर्ट फेल्ट दैट इट कुड नॉट वेट and it had to take immediate action. So on the basis of the headline, which it felt is a reliable headline, it took action. So that is the essence of suo motu cognizance. इसके साथ साथ एक और डॉक्ट्रीन हैंड इन हैंड चलता है. इसका नाम है डॉक्ट्रीन ऑफ जुडिशियल नोटिस. नाउ द डॉक्ट्रीन ऑफ जुडिशियल नोटिस इज बेसिकली वेयर द कोर्ट टेक्स जुडिशियल नोटिस ऑफ फैक्ट्स दैट आर सो ऑब्वियस दैट दे डोंट एक्चुअली हैव टू बी प्रूव्ड. Okay, so what happens is normally दो डिस्प्यूटिंग पार्टीज होती हैं और कोर्ट को अप्रोच करती हैं. तो ए फॉर इंस्टेंस डिस्प्यूट है ए और बी के बीच में. ए अपनी बात करेगा, बी अपनी बात करेगा, दोनों अपने फैक्ट्स आगे रखेंगे और उन फैक्ट्स के लिए ये अपना प्रूफ भी देंगे. लेकिन कुछ फैक्ट्स ऐसे होते हैं जिनके लिए प्रूफ की जरूरत ही नहीं होती. सो फॉर एग्जाम्पल the fact that the sun rises in the east, sets in the west, ये तो सबको पता है. Or for example, nations and their flags. Okay, so the court is going to take judicial notice of these facts that don't actually have to be proved. Public holidays, or in this case, for example, the COVID-19 pandemic. क्या किसी भी पार्टी को सुप्रीम कोर्ट के सामने प्रूव करना होगा कि कोविड-19 फैला हुआ है पूरी दुनिया में? नहीं, दिस इज एन ऑब्वियस फैक्ट दैट एवरीबडी नोज. और मोर रिसेंटली सबसे अच्छा एग्जाम्पल है अफगानिस्तान में जो हो रहा है. सिंस द तालिबान हैज टेकन ओवर, लेट्स से इफ आई एम रनिंग अ बिजनेस इन इंडिया और मेरा जितना भी सप्लाई आता है वो अफगानिस्तान से आता है. अब 1 महीने के लिए मेरा शिपमेंट टाइम पे नहीं आया और मैंने सूट डाल दिया किसी इंडियन कोर्ट में. सो the court is going to naturally realize and naturally say that the reason for the delay is probably because it's a country which is affected by war and it's not possible to carry out these commercial activities. And so it will not punish my supplier because that would be unfair to the supplier, right? It's not the supplier's fault that whatever my goods are not coming on time. So these are facts that the court has to take judicial notice on. Otherwise, your proceedings become extremely oppressive or they'll become tedious. अगर हर fact court को prove, मतलब court के सामने prove करना पड़े, the fact of, let's say, Taliban having been taken Afghanistan over, or the fact of COVID-19 pandemic, ये सारी चीजें अगर हमें prove करनी पड़ जाए, तो the proceedings are going to become extremely long, extremely tedious. So this is the reason that there are some things that the court already takes judicial notice of. COVID-19 is one of them. So what happened in this case? Well, I have to give you a little disclaimer. Whatever happened is not the most important. Like I said, I picked this headline up because I wanted to discuss suo motu cognizance and doctrine of judicial notice. But what basically happened is that the court took suo motu cognizance and it filed a PIL before itself on its own. And it extended the duration of all interim orders. Normally, जब A और B dispute लड़ रहे होते हैं, there is a permanent order and there's a temporary order. Permanent order केस खत्म होने के बाद पास होता है, temporary order केस खत्म होने के पहले या फिर पहले दिन पे या दूसरे दिन पे पास होता है. Temporary order will be in the nature of something that is preserving the property. If A and B are fighting over a certain property, to make sure that, let's say, A प्रॉपर्टी को कहीं बेच ना दे या B प्रॉपर्टी को कहीं बेच ना दे जब तक डिस्प्यूट चल रहा है, उसके लिए कोर्ट कुछ ऐसा ऑर्डर पास करेगा कि दोनों पार्टियां प्रॉपर्टी को छू ना पाए. सो इन सच अ केस दिस इज कॉल्ड एन इंटरिम ऑर्डर. Now, naturally, let's say the court passes an order saying that this property will not be sold off for 1 year. During COVID-19 pandemic, हमें पता है कि सारे कोर्ट्स बंद हैं. Litigating parties cannot approach the court. तो 1 साल तो ऐसे ही निकल जाएगा. So the court has said that whatever stage the cases are at, it's going to stay on that particular stage. Whatever interim or temporary orders that the court has passed, for instance, let's say that the property will not be sold off for a year, it will continue to remain at that stage till courts reopen or till the court passes further orders. So this is to provide relief to a litigating party, okay, because litigants have been able to approach the courts. इसी हेडलाइन के अंडर एक और कॉन्सेप्ट आता है PIL. ये कॉन्सेप्ट सबको पता है, इसीलिए मैं इसे सबसे लास्ट में डिस्कस कर रही हूँ. But basically, this is a concept evolved by Indian courts. So suo motu cognizance is something that is there in the Constitution itself. It came up in the 1970s, right, under Article 32 and 226. The doctrine of judicial notice is something that has been evolved by the British. ये अंग्रेजों के टाइम से प्रिंसिपल चला आ रहा है. Okay, but PIL is something that has been evolved by Indian courts. This is a domestically manufactured concept. So what the first case where PIL was applied is called Husainera Khatun versus State of Bihar, where the Supreme Court has taken action on the inhuman treatment of prisoners in Bihar. Okay, this was the first time that ये concept apply हुआ. लेकिन सबसे पहली बार जब ये define हुआ, that was the case of SP Gupta versus Union of India. And इसे किसने define किया? Justice PN Bhagwati ने. Okay, लेकिन ये concept है क्या? So normally, जब हम कोर्ट जाते हैं, there is a rule called locus standi. That is, जिसके rights violate हुए हैं, वही कोर्ट में जाएगा. And only he will have the right to approach the court regarding the right that has been violated. Okay, but normally, but in the case of a PIL, the PIL becomes an exception to this rule of locus standi. Locus standi literally means by what stand? By what stand have you approached the court, right? So PIL is an exception to this rule. Now, PIL means that any member of the public or any NGO, for example, can seek to enforce human rights. That NGO can approach the court and try to enforce the fundamental rights of those persons who can't approach the court. Kafi times you have socially and economically disadvantaged groups, SCs, STs, wherever across the country. तो कुछ NGOs होते हैं जिन्होंने जो एक्शन लेते हैं इन लोगों के लिए, इन डिसएडवांटेज ग्रुप्स के लिए. So this right has specifically been evolved for these NGOs and for these public-minded citizens. A few good examples of PILs are, for instance, Human Rights Law Network. They do a lot of PILs. MC Mehta versus Union of India has done so much work on the environment. So that was a whole series of PILs which has really benefited the country. Okay. So this is something, but this is an exception that applies only to socially or economically disadvantaged groups. ये सबके लिए नहीं है. तो ये ऐसा नहीं हो सकता कि मैं अपनी फ्रेंड के लिए कोई PIL फाइल कर रही हूँ, ये नहीं हो सकता. But definitely, if I am, let's say, a citizen in Delhi, and I feel that the police, let's say, is treating beggars or people who are living on the roads inhumanly, or the government is not making enough provisions for them, maybe I can approach the court. Maybe I can ask for their fundamental rights to be implemented. So these are examples in which PILs can be filed, and that is what the court did in this case. It filed a PIL for those litigants which could not approach the court, and it instituted it before itself because it can do so under the doctrine of suo motu cognizance. Okay, the next headline is the CJI has questioned the government of India on sedition. So जो चीफ जस्टिस ऑफ इंडिया है, उन्होंने गवर्नमेंट से ये सवाल पूछा है, why do we need a British made law, especially one like sedition after 75 years of independence. तो सबसे पहली बात हम सबको पता है, we have a new CJI. His name is N.V. Ramanna. So it's Honorable Justice N.V. Ramanna. But basically, what is sedition? Firstly, so it's, like I said, it's a British made law, and ये IPC में पड़ता है, section 124A of the IPC. But what it basically means is when one person is inciting some amount of hate or contempt or disaffection. Disaffection का मतलब होता है disloyalty or feelings of enmity against the government. Okay, but not just any government, against a government that has been established by law. So सिर्फ ऐसी government जो, for example, India में जो law है, elections लड़के power में आई है. So only such governments. So sedition basically means that a person is inciting some amount of hate, contempt, enmity, feelings of disloyalty towards the government. That person will be punishable with imprisonment either for life in very serious cases, or usually an imprisonment up to 3 years, which means jail to the maximum sentence of 3 years and fine. Okay, not more than that. But there are also certain exceptions to this offense. हम सबको पता है, we are living in a democracy. The right to criticize our government is our fundamental right. Okay, so the IPC cannot violate that fundamental right. So it makes an exception. What is the exception? It says comments that are genuinely criticizing the government with a view to change the actions are lawful. They are not sedition. मतलब ये हुआ कि कुछ ऐसे कमेंट्स जो हमारी गवर्नमेंट को जेन्युइनली बदलने की कोशिश कर रहे हैं, उनके एक्शंस को बदलने की कोशिश कर रहे हैं, वो सेडिशन में काउंट नहीं होगा. Okay, so those comments are not going to be punished. And also comments criticizing administrative or other action of the government without exciting or attempting to excite hatred, contempt, disaffection, whatever, they will not be constituted under sedition. So, which basically means कि अगर मैं किसी गवर्नमेंट डिपार्टमेंट को क्रिटिसाइज कर रही हूँ, अगर मैंने कहा कि DDA, दिल्ली डेवलपमेंट अथॉरिटी, बहुत स्लो है, बहुत करप्ट है, ये वो व्हाटएवर, और आई से दैट इंडियन ब्यूरोक्रेसी, जो IAS IPS सर्विसेज हैं उनमें बहुत स्लोली काम होता है, या फिर इट्स नॉट इनफ एंड इट मोर हैज टू बी डन, and I'm making this criticism without any attempt to excite sort of hatred or contempt or feelings of disloyalty or enmity against the government. मैं genuinely criticize कर रही हूँ. So these are going to be exceptions under the law of sedition. ये punishable नहीं है, ठीक है? But so basically, but what has happened is that the CJI has questioned the government कि ये जो law है section 124A का, ये अभी तक क्यों है? How did this question come up? Naturally, you guys need to understand context. ये हुआ क्या था कि एक retired army veteran थे, SG Bombardier, or Bombardier, I'm not sure how to pronounce it, but it's right here, you can see it on the screen. A retired army veteran had filed a petition challenging the validity of the law, challenging the constitutionality of section 124A. And, sedition has been in the media for a very long time. और सब जगह एक ही क्रिटिसिज्म है लॉ का कि ये फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन को वायलेट कर रहा है, ये सब जानते हैं. So, and it was not just this man, it was not just this army veteran. दूसरे NGOs और दूसरे media houses भी, for example, Editors Guild of India, ऐसे petitions उन्होंने भी फाइल करे, और सुप्रीम कोर्ट ने क्या किया कि वो सारे petitions कंबाइन कर दिए और एक साथ उनकी हियरिंग करी. डिबेट क्या है सेडिशन का? So, firstly, the CJI has said that a law like this should not have any place in modern democracy. The point is कि what he's trying to say is, what is the point of such a law? ऐसा law हमारे कॉन्स्टिट्यूशन में या फिर हमारे किसी भी legislation में है ही क्यों? What does it mean when you say you're exciting hate or contempt or disloyalty? ये तो कोई भी comment, कोई भी genuine criticism भी आप मतलब ऐसे बोल सकते हैं कि it's hate or it is exciting feelings of enmity against the state, right? A person has a right to protest. So oftentimes it may happen कि if the government is politically oriented for their own political interest, उन्होंने कोई भी ऐसा comment hateful comments के category में रख दिया और कोई भी comment दूसरा comment अपनी genuine category में रख दिया. Okay, so it can, the political party can exercise its own politically vested interest. What if there is a person who is criticizing the government and you have maybe that person is punished for sedition? How will that person show that his comment was to genuinely criticize the government and not to excite some sort of disloyalty or disaffection against the government? So this is a very ambiguous, it's a very vague provision. इसका कुछ कह नहीं सकते, like how those proceedings will be taken on in court, how evidence will be led. These things are very vague. It's a gray area. So this is what the CJI has said. He's also given an example, a very interesting example of Section 66A of the Information Technology Act. Now, we all know that Section 66A was introduced in 2008. After that, it was struck down by Shreya Singhal versus Union of India's judgment, right? The Supreme Court struck it down. Section 66A क्या कहता था? It said, any person who posts menacing or offensive or false or threatening content or information on the internet would be punished with imprisonment for a term which may extend to 3 years with fine. What that basically means is, if you have posted something that is offensive, or it is false, or it is like basically threatening someone, you are going to be punished with imprisonment. But who decides what is menacing and what is offensive? What is offensive to me may not be offensive to you, or what is offensive to somebody else may not be offensive to society in general, or what is offensive to society in general may not be offensive to one particular individual. So who decides what is menacing or what is offensive? Okay, well, obviously it's a court of law. और actually court of law तो बाद में आता है, सबसे पहले तो executive action होता है. So the government or the executive authorities decide that what is offensive. What if I post something against the Congress or against the BJP or whatever political party in power, and they decide that my tweet or my Instagram post is offensive? I'd be punished, right? So Section 66A on this ground was struck down, saying that it was against freedom of speech and expression. और CJI ने Section 66A का example लेते हुए ये comment किया कि sedition भी कुछ इसी तरीके का लगता है. You know, the language used within the ambit of sedition is very much like Section 66A. ये दोनों बहुत ही similar sound करते हैं. So just like how 66A was a tool to suppress free speech and eventually उसे unconstitutional माना गया श्रेया सिंघल versus Union of India में, सेडिशन भी कुछ ऐसा ही है. और गवर्नमेंट को इसे अपने आप रिमूव करने की कोशिश करनी चाहिए या फिर कंसिडर करना, ये बात इस पे डिबेट होना चाहिए, इस पे कंसिडर करना चाहिए. सो बेसिकली ही इज ट्राइंग टू encourage the state, encourage the legislature to remove this on its own, because ये चीज सुप्रीम कोर्ट हटाए, it is better that the government do it itself. So this is a really important question, I think, because maybe you get some sort of an essay like question asking you to express your opinion on sedition, whether it's a good law, whether it's a bad law, do we need it, are the comments justified, things like that. So I would say that you read up on external sources, see what is the debate in mainstream media, and see what try to form an opinion on the subject. Okay.